build one, South Africa leader Mmusi Maimane has confirmed he will launch a constitutional court challenge against the recently signed Electoral Act. Maimane is accusing President Cyril Ramaphosa of what he describes as a malicious implementation of the constitutional court ruling. Athi Mtongana caught up with him earlier.
Well, in essence, what they're saying is that they're challenging this electoral amendment bill that has now been signed by President Cyril Ramaphosa on Monday. So they'll be heading to the Constitutional Court. You're right, I am joined by Mr. Maimane. Thank you for your time. Now, I think I want to begin by this point, given how lengthy this process has been. Where were you involved in this process? Because we understand that when the Constitutional Court judgment came out in 2020, Parliament dragged its feet, deferred it to the Executive and the Minister of Home Affairs. At what stage were you then involved to say, we're raising issues with certain elements of this amendment?
Well, thank you very much. I think it's important to note the fact that even the initial judgment, that the application that was done by the New Nation movement, we had been part of that whole exercise to ensure that there was an amending of the electoral bill through our colleague Michael Louis. Furthermore, that when after the Concord judgment, we issued an alternative bill. You'll recall we worked with Honorable Mmusi Maimane to table that private member's bill. Much of the submissions that were made there, we did. Furthermore, when the Ministerial Advisory Committee that was set up by Minister Aaron Motsoaledi, I made submissions to say, here's what we'd like to see in the law, and ultimately in the public submissions that Parliament were meant to do earlier on, they didn't do them, and we put pressure on them to say, you need to come and represent the voice of the people. They failed at that exercise. So all the way throughout this process we've been involved. And it's precisely when we anticipated that we are dealing with a Parliament, a government that wants to just maliciously comply with the Constitutional Court without really giving substance to democracy to the people, that we started BOSA to say, let's allow for communities to be able to be represented in Parliament by the people. It's all the way throughout that process that we've been engaged.
Now, so the issue that you're taking to the Constitutional Court is one that needs explanation insofar as why do you view this as unconstitutional, and how do you think it sets up independent candidates in a prejudiced position?
Well, firstly, it favors, naturally, when you draft a law, it needs to have a sense of fairness and equity for everybody, right? So there are a couple of things. One is, it makes it hard for anyone who wants to represent their community to be able to stand for a number of reasons. One, the threshold of signatures that they need are higher than that of a political party. Secondly, it doesn't articulate the issue of constituencies. It's a person versus a well-funded political machine, whereas ultimately, and constituencies themselves are provinces, which means that if you live on one end of the province, how can you represent the other end of the province? We should have made it constituency-based. Thirdly, we think that post facto, when you calculate votes, the number of votes an individual would need to qualify for a seat are 87% higher than that of a political party. So it's not fair, it's not equitable. And the costing that will go into it does not help. And it's why we need to amend the system, we need to ensure that it works properly and fairly, and we think that the Constitutional Court must give directives so that we have an electoral system that is fair for everybody. My interest is making sure the rule of law stands.